Lesson 5, Leases and Property Management, Key Concept Review. Key Concept Review. We've talked about leasehold estates for most of this chapter. The big deal with the leasehold is it's a temporary estate that the landlord has given possession of his property to a tenant for usually a period of time. Sometimes it's specified, sometimes it's not for the period of time. But eventually the property will come back to the landlord. Tenants, no matter for how long their lease is, they can't somehow claim ownership to it. Their rights, a tenant's rights will always be subservient to the landlord's. The types of leases we want to know, we have the estate for years, and a big deal with the estate for years is it's for a specific period of time. And that's important because neither party has to give notice to terminate that. Now, the other types of estates are periodic estates. Those are for a period to period. And that means that because nobody knows when they're exactly going to end, one of the parties has got to give notice to terminate that. Whether it be for a month to month, or week to week, or even day to day. Somebody's got to give notice. Typically, we give notice in the same period of time that we're paying rent. Estate at will, we talked about that. That's the temporary estate that will come to an end on the happening of an event. And in the example I gave earlier, it was when the first unit was made habitable and repair was made, and then the tenancy at will, where the tenant was in the other unit, terminated. And we would rejoin his regular lease. Tenancy at sufferance, that's actually an illegal tenancy. That means you have a tenant that isn't leaving, and then you have to evict them. So that's a tenant at sufferance. Leases are contracts in which one party pays another party a rent for possession of the property. That's typically what a definition of a lease is. And I've talked about, this reversionary right means that the landlord always has a reversionary right to get his property back at some point in time. Leases have to contain essential elements. We need the demising clause where the landlord is promising the tenant that they can have possession. So that's called the demising clause. We have to have the time period for the lease, the duration, and the amount of the rent. We have to have a description of the property that we're renting somewhere. Maybe even it's just an address. That's okay too. And of course, we have to have the parties sign the lease. Usually, we have security deposits involved. We have the right of subleasing and the right of assigning. Typically, certainly commercial leases do. Remember, residential leases, if it's built prior to 1978, we have to be careful about the lead-based paint disclosures that will have to be made. And in Illinois, we have to indicate if these are separate units, if there's separate meters or there's one meter, and who's responsible for paying the utilities. Gross lease, talked about that. That's called a gross lease because the amount that goes to the landlord is a gross number. We have the net lease, where the amount that goes to the landlord is a net number because the commercial tenants paid all the expenses. Percentage lease we've talked about. Land leases, graduated leases, we've talked about those. Security deposit is pay the landlord in case there's damage to the property. The big thing with the security deposits in Illinois is there are some rules that apply to them. First of all, if in Illinois, if anybody withholds security deposits, then the landlord or their representative have to give the tenants within 30 days an itemized list of the damage and what was paid out of the receipts. So you got to do that within 30 days. You can't just take their security deposit and say, sorry, Mr. Tenant, you caused some damage, so I'm going to take the money and it's going to cost me, $500 or $1,000. You have to give an itemized list of the damages, the repairs, how much you paid for it before you take any of their security deposit. And if you don't use all of it, you have to return it to them. Owners with 25 or more units have to also pay security deposits. So in Illinois, if any owner or landlord has 25 or more units, they have to give their tenants, when they leave, interest on their security deposit. And in Illinois, the amount of interest is based on Illinois' passbook savings rate for Illinois' largest bank. And the passbook savings on most banks are not very much. Some are 0.5%, some are even 1%. So typically this isn't going to be a lot of money. Okay, but that's how we would compute the amount of security deposit. We'd find the passbook savings rate of Illinois' largest savings bank, and on the day that the landlord left, the day that the tenant left, and we'd multiply that by the amount of security deposit, the $500 or $400, and we'll take 1% of that, and we have to pay him $40. Assignment we talked about. Okay, the big deal with the assignment is the original tenant, I think our example was a commercial tenant, is now out of the deal, and they can go to their other place, and the new tenant will step in their shoes, if you will, and finish out the term of the lease. Sublease is where the original tenant is going to come back, and the original tenant remains liable even when the subtenant is in the unit. Landlord doesn't care about your sublease. He wants his rent. Leases can be terminated in a number of ways. Obviously, expiration of the lease time. We have our estate for years from January 1 to December 31. December 31, lease terminates. There are some other ways that they can terminate. One of the parties gives notice to terminate, so that would do it. Eviction will also terminate a lease. Property manager is hired by a property owner to market and merchandise, maintain the property. Usually the investor owner will hire a brokerage firm that has a managing broker running it. In Illinois, we can hire residential leasing agents to collect rents on residential property. They can negotiate leases and work with tenants just on residential properties, these residential leasing agents. Important to know, residential leasing agents can't lease out or work with commercial tenants, and the residential leasing agent can't work certainly in the brokerage field. So if they decide they want to go and list and sell real estate at some point in time, they're going to have to get a regular broker's license. Your book makes a big deal about property managers being general agents. Okay. Property management agreement is the employment agreement in writing that governs the relationship between the property owner, investor, and the property manager. These are some of the provisions that would be in a property management agreement. The description of the property, the length of the agreement, the authority that the property manager has, their duties, their fees they're going to charge, reports that they have to give, insurance risk management duties they might be tasked with. Typically, property managers are paid a percentage of the gross lease, the gross rentals that they collected in a given month. So usually property managers get a percentage each month of the total amount of rentals that they collected. Talked a little bit about the proposal, which is very similar to the contract, the property management contract. Part of what your property managers will need to do is provide regular financial reporting on the property, operating and create an operating budget. Usually, they may take a look at over a 5-year period of time as they're trying to determine budgeting. So, and as they look at that, they'll look at their fixed expenses and their variable expenses, other reports as they come up with their budget. Market rent, we talked about fixed expenses, variable expenses, reserves. The property manager will have to make sure that there are reserves being held for a future, expenses that might be coming up, future replacement, future repair of major items. So we'll have to keep in our banking account reserves for these kinds of expenses in the future. Operating expenses don't include debt service or depreciation. Okay, so that's going to be separate. Operating expenses are just that. They're expenses that are directly related to operating a property, and not debt service or depreciation. Debt service being what you're paying on what the landlord's paying for his mortgage. Mortgage depreciation being that quote depreciation write-off that investors are entitled to. Primary task of property managers and landlords is finding tenants. In the process of finding tenants, we have to be careful about steering. We don't want to steer people, prospective tenants, to specific properties or neighborhoods based on their membership in a protected class. That's prohibited. ADA. We have to remember that those with disabilities do have protections, mental, physical disabilities, particularly if they're in a drug or alcohol protection program. They're protected against discrimination in housing. Those with HIV, we protect the knowledge that they have HIV from other parties if we're aware that they have HIV, if they're HIV positive or have, in fact, the AIDS virus. Again, eviction we talked about. With eviction, there's actual eviction. That's where the landlord actually goes as a legal process to court to get someone out of their property. The steps for eviction start with notice to quit. You have to give that. You would file a forcible entry and detainer action with the court. And these are all done under very strict timelines and very strict rules. So, Mr. Landlord, if you're going to evict somebody, you really have to follow these things very closely, or the court will just kick you out and you'll have to go back and start all over again until you get through it. If at the end of this the court agrees and they agree to forcibly remove a tenant, then we bring that up to the sheriff. So the sheriff is really going to be the one to forcibly move somebody and their belongings. You don't do that as the landlord, or you wouldn't do that as the representative of the landlord. You're the property management company. Self-help evictions. No such thing as self-help evictions. They're illegal. You can't just go in and take their front door off and remove all their furniture when they're not there. And of course, retaliatory eviction, threatening people to evict them if they report any of building code violations that might be on their property. Continue to lesson 5 and to the chapter quiz.